Ravi Batra is an eminent lawyer, and in this discussion with Lalit K. Jha, he discusses the impact of Donald Trump's indictment on his re-election bid. This is a New India Abroad video.
Timeline of this case, what's going to happen from here till the case finally closes, reaches its conclusion. What are the various options? How many years or months is going to take? Remember, it's for the Indian audience.
Okay. So normally you would expect a motion to dismiss. Generally, they are not granted because the motion to dismiss simply says to the judge presiding, "Judge, take a look at the grand jury transcripts and make sure that each crime that's been charged, the elements are present in the evidence that the grand jury got." Okay? Because the defense attorneys do not have the transcript of the grand jury proceedings. They remain secret. All right? So this motion is a very short motion asking the court, Judge, for the rule of law's sake, please take a look at all of this transcripts, go over the evidence, and make sure all the elements are met. To make a simple point of this, if, for example, you accuse a person of being pregnant, well, and the judge looks at the record and says, wait a minute, the person you're accusing of being pregnant is a man. Well, a man can't be pregnant, so that count is dismissed. Okay? So just to make it very simple for the lay audience. So that's the first normal rule. After that's done, typically those motions are denied. And then you move on to discovery, where the prosecutors are under federal constitutional obligations, Brady obligations, to turn over exculpatory information, which means any evidence the prosecutor has which helps Donald Trump prove his innocence, you have to turn it over. Not only the evidence that they want to convict him with, but also the evidence that allows him to walk away free. And then, so that's the normal Brady material. And so now once the defendant has what the federal law requires, and New York State has even more discovery obligations recently imposed upon prosecutors, which some people are complaining about, that it's too defendant friendly. Well, now, at least the Republicans in America will be very happy that New York State is defendant friendly by having this extra discovery obligations imposed upon District Attorney Alvin Bragg, because Donald Trump will be a beneficiary of this. So his defense lawyers will get all of this, they will review it, and then they will make whatever additional motions to dismiss, including, for example, statute of limitations. You waited too long, this is not enough time, that you come too late to court, etc. One additional motion that is not normally made, but here it could be made. It's a change of venue. The case is in Manhattan, and Manhattan probably is 85%, 80%, something like this, Democratic, maybe 20%, maybe 15% Republican. But the last voting will tell you, more precisely. And so the argument would be, well, we're not going to get a fair trial here we can't get a fair jury. Actually, that's a false argument, because if you love Trump, you can't sit on the jury. If you hate Trump, you cannot sit on the jury. So people who are going to end up on the jury have to swear an oath that they will be fair and impartial, and they're not coming in with any preconceived mind. If they think he's guilty or if they think he's innocent, they can't sit. So there are many, many hardworking New Yorkers who are busy trying to have a life, that they may not be paying attention to all the politics and all the rhetoric. So there may well be not only the 12 jurors you need, but you need maybe 6 or maybe even a dozen alternates as backup in case somebody is excused for sickness, or because this case may go on for a long time. 34 counts. You can imagine that this would be a several-week trial. It could be the trial could last over a month, well over a month. And the most powerful weapon that the Constitution gives to every defendant, aside from presumptive innocence, which Mr. Trump has, but the most powerful weapon beyond this cloak is the right to confront the witnesses against you. So his lawyers have the ability to pierce through the credibility and to try to get the truth out of people they believe are lying on the witness stand. And if they cannot do that, but the jury will see that. And so you have to be careful how you do this. If you're overbearing, the jury doesn't like it. So, things have to be done in a fair way, in a proper way, in a respectful way, with decorum. Not necessarily people who make a lot of noise in court are loved by the jury.
So this will continue
with a lot of noise.
So this case might take 4 or 5 months. So
in New York, we have something called interlocutory appeals. So when a judge issues an order, if any party is aggrieved, certainly the defendant, they can take an appeal. And when they take the appeal, then that delays the process. Federal court, you don't have interlocutory appeals as of right. You can get leave for it, but you don't have it as of right in most situations. So it wouldn't be unusual if this case took 2 years or more to try, which means by next summer of 2024, when the conventions are being held, this case will not have been tried. In fact, it may not even be tried before the election takes place.
Mm-hmm.
But anybody who's thinking that if he was to get elected in 2024, and I'm not answering the political question of whether he could or couldn't, that's a separate conversation. Let's assume for a minute he could. It would only delay the sentencing. He could not get a pardon. He couldn't do it for himself, nor could anybody give him a pardon, because a federal president cannot pardon someone of state crimes. Okay, President Biden could pardon him, for example, if Special Counsel Jack Smith brought charges against him in federal court, convicted him, and then President Biden or a subsequent president could pardon those federal crimes or charged crimes. But only a state governor can pardon these state crimes. So it's not the White House.